You're listening to People, Places, Planet, the official podcast of the Environmental Law Institute, a nonpartisan, nonprofit research and education institute making law work for people, places, and the planet. If you enjoy the podcast and want to support our work, consider donating at eli.org/donate.
Welcome, listeners, to another episode of People, Places, Planet. I'm your host, Sebastian Duque-Rios. When we talk about ocean governance, we often focus on conservation targets, marine protected areas, sustainable fisheries, or emerging issues like deep-sea mining and marine geoengineering. But far less often do we ask a more fundamental question: who benefits from ocean governance, and who bears its cost? Today's episode explores the concept of ocean equity, an emerging framework that seeks to center justice, power, and historical marginalization in the way we govern marine resources. As climate change reshapes ocean ecosystems, and as economic pressures intensify, decisions about access, conservation, and development are becoming even more consequential for coastal and indigenous communities. To help us unpack this, I'm joined by Yoshi Oda, founder of Ocean Nexus, and Randy Abate, a leading scholar in environmental and climate justice. Together, they propose a shift in ocean law and policy, from consultation to meaningful consent, from equality to equity, and from conservation models that exclude communities to stewardship models that recognize their central role. We'll discuss anti-subordination theory, the rights of nature movement, and why new governance spaces like deep-sea mining present a critical opportunity to embed equity from the outset. Yoshi and Randy, welcome to the podcast. Let's dive in.
Thank you. It's a great opportunity and just wonderful to be here with Randy.
Thanks so much for having us, Sebastian. Great to be here with Yoshi and eager to dive into this conversation.
Well, to start us off and give our listeners a little bit more context on your work, would you both like to briefly introduce yourselves and your previous work in connection to this topic? Starting with you, Randy.
Certainly. I've been a career environmental law professor in the past 2 decades, focused in the climate justice, environmental justice, human rights and environment space, with a background and interest in ocean governance. And that more recently has translated into working in this space of ocean equity with Yoshi and the work of Ocean Nexus. So that's been a recent and exciting development. Excited to talk about that today, and very much looking to continue to uplift the voices of disproportionately burdened communities across these disciplines.
My engagement with this topic, ocean equity, actually started 2011. I started this project called the NERIS project, started with the UBC, had a collaboration with Princeton and then Cambridge and then Duke. And what we're trying to do is predict the future ocean, how climate change as a driver to change the ocean, to change the community, change the economic. So that was really the first start. And at the end of the project, we came to 2 conclusions. One, climate change, bad news. I mean, everybody knows about it. The other one is inequality that we actually see for distribution of the benefit of the ocean will actually be larger. That was really something, we didn't expect it when we actually started working on it. And that was like 2018, 17. And the people working in the ocean cannot really miss the impact of the climate change. But this inequality part of it, we need a capacity. So that's when I started this new project called the Ocean Nexus. So the Ocean Nexus has been going on for the last 5 years, really to trying to develop the capacity in ocean governance, to consider social equity at the center of our management, conservation, and governance. So that's what I've been leading, but I'm trained as an anthropologist. So legal part of it, I need to seek for the huge help. That's when I start working and collaborating with Randy.
It is great to have you both here today. I'm really excited to hear a little bit more about the work that you've been doing together in ocean equity, as well as Ocean Nexus's work in advancing and framing this idea. And so to set the scene a little, can we start at a high level? What do we mean by ocean equity, and what problem is it trying to solve in contemporary ocean governance?
So the climate change drives the ocean. If we consider ocean as a pie, the pie of the ocean gets smaller. And when the pie gets smaller, the distribution will actually change. Those bigger players, unfortunately, historically, doesn't really want to give up the size of the pie. So they want to keep their pies bigger, and that pushes people who doesn't really have a power, kind of like a more marginalized. And then that creates more inequality. So that's really was a concern. The idea of the ocean equity is, okay, we need to consider this change happening both in the ocean and society, and really to develop our governance structure more towards dismantling systemic issues. So that's really what the ocean equity to us. The one thing which is really important for us to consider ocean equity is it's not equality, So the equity and the equality are very different things. We are not really looking to just give everybody's have a same opportunity. Everybody have a same distribution. That's not what the equity is. Equity is really to consider those who are underrepresented and marginalized to have capacity and the power to stand at the same starting point. So that's really what equity is. So the ocean equity, in my understanding and in Ocean Nexus understanding, is really to bring the conversation of social justice at the center of the ocean governance, which we tend not to talk so much about it. That is really the core of it.
Thank you, Yoshi. And maybe for our listeners to really get a grasp of this concept, could you ground it in a concrete example?
Yeah. So let me just go back a little bit. This idea of putting equity or justice in ocean governance really started from like 1990s. It started with fisheries, ecosystem services, MPA, and thinking about SDGs and blue economy. It's more like the implementation. How can we implement what we think is a solution in the ocean without disturbing coastal community? So that really was the core mission of bringing this equity. What I have seen and missing is really to just bring this conversation about social justice. So let's go to the concrete example. When we talk about ocean governance, it's often the case that we don't really consider topics such as race or colonialism or gender-based discrimination as the core issues that's driving this systemic structure, making the unequal distribution of the benefit, or potentially even creating the marginalized groups who cannot really represent themselves well enough. So what we need to do is dismantling these systemic issues that in legal terms could potentially include litigations that really gives the power to the community to say no to some of the policies which has already been decided. One of the most recent work that we are trying to do is really to address the suffering and the marginalization happening in Latin America small-scale fishers. And this is happening between small-scale fishers and new development. There are conflicts everywhere between coastal communities and developers. And the developers coming from tourism or refinery. But the community doesn't really have enough legal power to veto these decisions or even just work against it. And this is particularly important for the small-scale fisheries because they cannot really have an alternative so immediately. And also, it's not just only the commercial purposes they engage in with fisheries, it's their lives and heritage. This is not something they can actually replace it. So those are the things which we're trying to address.
And Yoshi, to follow up on that, what are some approaches or strategies that Ocean Nexus is utilizing to address ocean equity or to advance it?
We are trying to work with three main frameworks to address ocean equity. One is discredit destructive narratives, which basically means, there are a lot of overselling of the solutions, and that's not really backed up with data. For example, blue economy. How much of the blue economy is promising can actually be materialized. Often those information are not available. And the dignity part is the second one. We tend not to listen to those groups of people who really being pushed in terms of policy decisions. And the last part is really legal framework. How can we really address this ocean equity, which some of the audience potentially think like we're still not really sure what you're talking about. And that's what the anti-subordination approach, which, I'm hoping Randy will speak about next.
Thank you, Yoshi. And I think it's really important that organizations such as Ocean Nexus and ELI, who are working to establish socially equitable, environmentally sustainable, and economically viable ocean sectors, are also thinking about how laws and policies materialize on the ground for communities. As you touched upon, Elevating local and Indigenous voices during the legal and policymaking process is critical to achieving a blue economy. And I think some of the terms that you've begun introducing into the body that makes up ocean equity remind me and might remind our listeners a lot of some other terms that they might be more familiar with, such as environmental justice or climate justice. And so I'm curious to ask, how does ocean equity build on the work of environmental justice and climate justice, and where might it maybe be pushing those frameworks further or differing from them?
Yeah, so there's certainly a trajectory that we can trace from environmental justice into climate justice and into where we are with ocean equity. These are related but distinct areas in the sense that environmental justice got its start in the 1990s on this premise that there were disproportionate burdens that certain communities were experiencing on the basis of race. Where environmental justice and climate justice, which followed on its coattails, where they fell short was this idea that these disproportionate burdens were happening, and yet the law did not provide enough of a remedy for that reality. And environmental justice hit a big roadblock in that regard when they were seeking to have the law protect against those realities. And the courts came out and said, we're not going to provide a remedy for those societal realities unless there's evidence of intentional discrimination against those communities. And you can imagine how difficult that is to establish. Some testimony on a legislative record that says we want Black communities to suffer more from pollution impacts. You're going to have a very hard time finding that, and therefore the remedy was not there after the problem had been identified. Ocean equity seeks to go the next step beyond where we've seen environmental justice and climate justice, which have been very positive developments. We certainly see more procedural access and access to justice opportunities in environmental justice and climate justice. But what ocean equity seeks to do in taking the next step is to provide a remedy that seeks to address that historical evidence of marginalizing these communities and correcting it.
If I can add it, when we bring those conversations in the ocean, people tend to see, okay, that's more like a land thing. We're talking about ocean. People don't live there. So why do we want to mix those conversations? But we certainly know that people may not live there, but they live on it. And so that we consider ocean as an extension of our society, our land. And that really is one of the most fundamental shifts that we have to make in ocean governance, which we've been having it historically, and many scholars have made effort to it, but ocean equity even push it forward and advance this concept.
Yeah, that's a really fantastic point, Yoshi. And I think, you shouldn't just imagine the immediate area around the community as that extension, but really what happens 100 miles away in the ocean will have a huge impact on what's happening in that coastal community as well. And so in your manuscript, which is currently under review for publication, Ocean Equity and Anti-Subordination, Embracing and Protecting People for the Planet Model of Marine Governance, you propose ocean equity and reframe the approach that we should be taking towards ocean governance as one that relies on a theory of anti-subordination. This legal theory outlines how guarantees of equal citizenship cannot be fulfilled as long as pervasive social systems continue, and that the law should reform institutions and practices that perpetuate the historically subordinate status of certain groups. So, from my understanding, this theory is really aimed at tackling those systemic and historical processes of marginalization that we've been discussing. I'm curious to hear a little bit more about how this theory and its application differs from traditional anti-discrimination approaches.
Yes, those anti-classification efforts ultimately fell short, which is why we're proposing this paradigm shift that fundamentally, when we're looking at trying to undo historical and systemic problems that burden certain communities, the U.S. Constitution and the 14th Amendment has a tradition of putting those efforts under a strict scrutiny lens, that to the extent you're going to try to favor communities on the basis of race, on the basis of gender, on the basis of ethnicity, that's going to be something that is very difficult to ultimately succeed in doing. And we saw this with the history of affirmative action programs in this country. They were seeking to undo that historical burdening of communities on the basis of these classifications, and many of them failed because there was that presumption against that kind of race consciousness or gender consciousness to kind of level the playing field of what historically had been a fundamentally unfair landscape. Where ocean equity can go in applying this kind of anti-subordination approach is to not be encumbered by that sort of thinking and ultimately put those burdened communities' interests first as a way to address historical legacies of burdens. And so this is similar to approaches that we're seeing more generally outside the US as applied to Indigenous communities, for instance, the proposal to provide reparations for Indigenous communities to help undo this legacy of colonialism and marginalization. The land back movement, another example of how to correct those past wrongs. And that's what we need to do in the ocean equity landscape, that these burdens have been going on for generations, and ultimately the law has the capacity to level the playing field in a way that enables these communities to be entitled to what they have sought and what they have been experiencing diminished access to.
So that gives us an idea of anti-subordination theory as a concept and how it can be applied to ocean governance. But I would like to hear a little bit more about what are the 3 applications that you all propose in terms of how this can be directly applied to ocean governance.
So one example of how this might be operationalized in a legal context is this notion of free, prior, informed consent, which has wide-scale application outside of the marine environment and certainly has application in the marine environment as well. And so an example of how this has not gone far enough in its prior applications is this notion of, even though the term includes the word consent, free, prior, and informed consent has not been respected as conferring a veto power to those Indigenous communities that are being subject to projects that would ultimately negatively impact their lands and their resources. Ultimately, this proposal of anti-subordination is extending that to where it should extend on land or at sea. And the idea being that to the extent that you have a community that is, in fact, a sovereign entity with generations of access and relationships with these marine resources, they should be able to not only participate and be consulted in that process of what affects their sovereign territory and resources, but ultimately determine that something that would have adverse effects should not occur. And there have been virtually no examples of free, prior, and informed consent being interpreted favorably in this veto power kind of way.
That's a really interesting intervention to bring forward to make some of these consultation processes that I do think have not actually been that useful for a lot of communities in terms of getting involved or have not properly given them a voice. Something I'm more curious of is like, what would it actually mean to treat free, prior, and informed consent as a substantive right with veto power? What would that look like when a project is being proposed either directly on the coastline or even miles away into the ocean? So what would that process look like with the veto power incorporated?
Well, it certainly wouldn't be a guarantee of the outcome these communities seek in all instances by any means. We have many important competing interests here. We have governmental interests, we have private sector interests, and we can't simply allow the effect of this to create an outcome where economic development doesn't happen in any capacity. I think it may need, at least initially, to be context specific. What is the most equitable outcome here? Can something be done a different way such that these rights of these communities to ultimately engage the way they have been and want to continue, whether that can be upheld? And so one example is that we're certainly entering an era of climate mobility crisis. And to the extent that there have been efforts to relocate communities that are in harm's way, that are ultimately not going to be able to stay where they currently live, there is an assumption built into how the law is going to respond to that, that requires that before those communities are moved from where they call home, consent must be secured from them. And often those communities will choose the opportunity to stay where they are, even though it's gravely in danger from climate-related threats.
So, one of the things which is really important in this conversation is often we call everybody pretty much as a stakeholder. We shouldn't really put the coastal communities and like the industrial interest or sectors really at the same platform. It's almost like asking everybody that you have to run 100 meters, assuming everybody's on the same starting line. And then that's not the case. And then that hasn't been the case. So ocean equity or the equity itself really just consider, okay, how can we actually, those who've been marginalized historically, who really haven't had a chance to speak or raise the voice, can actually have a fair game. That's what really ocean equity matters in that conversation. So I just really wanted to emphasize, and that's really the difference between equality and equity.
On Yoshi's point, I think a case study that might be useful here in illustrating how this might look in applying laws through an ocean equity lens. In Ecuador, there was a rights of nature law that was recently passed and upheld in a context where there was a certain area off the coast of Ecuador that was designated as protected by the rights of nature. Ultimately, it was challenged by a commercial fishing entity that said this law provided small-scale fishing access, but prohibited commercial fishing access. And that was alleged to be a violation of their rights by the commercial fishing entity. And ultimately, the court upheld the rights of nature protection, holding that it was perfectly consistent and valid to prohibit that commercial fishing engagement in that area and yet allow the indigenous and coastal communities to have that much smaller scale access to uphold their traditional relationship with those waters. So I think that's a good example of how ocean equity can be reflected and intersects with rights of nature in ultimately creating win-win opportunities where the environment is being protected ambitiously and at the same time we're upholding the rights of traditional and small-scale fishing communities' interests in those waters.
Great. Well, thank you both. And the second application that you discuss in the manuscript is this idea of recognizing equitable use as stewardship. You discuss how some contemporary ocean governance schemes ban all types of use in protected areas. For example, certain no-take zones have included blanket restrictions on small-scale fishing and traditional uses of marine resources. Your paper argues that these regulations undermine the role that indigenous and coastal communities play as reliable stewards of environmental resources, especially given their interdependence with nature. You also highlight that some ocean governance schemes have embraced an approach that recognizes equitable use of marine resources as a form of stewardship. For example, the U.S. National Park System and the U.S. National Marine Sanctuary System include a sustainable use approach to conservation. Additionally, the Aboriginal subsistence exception to the International Convention on the Regulation of Whaling is another example of recognizing equitable use. So my question is, why do some ocean governance approaches view conservation as opposed to equitable resource use? And how do indigenous and small-scale fishing communities challenge the assumption that all use is environmentally harmful?
I mean, unfortunately, this shift in fisheries governance has been happening everywhere. They just approaching more modernized way of maybe providing quota, maybe creating marine protected area. All sorts of way of doing it is really often missing this idea of coastal community generally wanting to preserve their stocks and really just keep this livelihood going on. And that's often tough things to accept because there's a lot of assumptions, fishers wanting to catch more. They just wanting to make more money. It's true to some extent, but at the same time, there has been histories of the evidence that people also wanting to preserve. And the reason why they can't really do it is they have a very external demand, which actually stops their own governance structures, which traditionally held in many places. I fished with many small-scale fishers from Japan to Palau to France to UK. And then often the pressure is really coming from somewhere else, not their own fish stock. That really needs to be considered. But I often see the trend where the small-scale fisheries governance or management is asking those communities, is they're asking more data and more modernization, rather than trying to consider how can we actually protect the sovereignty as well as their way of doing it to be much more free from disturbance from the outside.
So, as we briefly touched on, marine protected areas are one of these aspects that this application of anti-subordination and ocean equity treats as an interesting case study or an area to consider where there could be more ocean equity principles brought into the process of creating and managing marine protected areas. And so, though they're often cited as a success story and they are considered important regulatory tools at the domestic and international levels, I'm curious to hear a little bit more about where they fall short from an equity perspective, and even more importantly, how they can be improved.
Yes, and this actually tracks my journey in the ocean governance space, because when I was teaching ocean law 10, 15 years ago, I was a big proponent of marine protected areas. The more restrictive, the better. If we're going to address the environmental challenges that we face in the marine environment, marine protected areas just seem to me to be this great way of fighting back against that legacy of pollution and overconsumption. I didn't fully think through how that aggressive environmental protection approach would impact the communities that have traditionally and historically managed those areas, lived in harmony with those areas, and ultimately served as the best stewards of those resources in those areas. And so it's very much like what we see in the land-based context as well, when the movement of REDD, reducing emissions from deforestation and forest degradation, was imposed in developing countries. It was this mandate of, we're trying to do this great environmental protection goal of enhancing forests as sinks in the war against climate change. But in doing so, quite counterintuitively, to implement those REDD projects, the forests where the conservation was supposed to occur would ultimately take place by having governments kick the existing forest dwelling and indigenous communities who had served as stewards of those areas out of that area, because it was now going to be government controlled, and we don't need those communities because they're perceived as threats to that goal now of leaving the forest intact. That same disconnect is going on in the marine environment, that we want to work with and uphold those existing coastal and indigenous communities and the relationship to these resources in the marine environment, because they are the most reliable stewards and not some externally imposed environmental protection mandate.
Thank you, Randy. And I think something that's interesting to think about too is that there are some tools and frameworks out there that would, both on land and on water, allow for the exception and some use of these resources by communities that traditionally and historically have used them. But I think it's also an important question to think about the difficulty that some communities face in the process of being recognized as historical and traditional users of these resources. That's something that I've thought about in my own research as well on land and in Latin America, about how there are a lot of countries or states that permit indigenous communities to continue residing, let's say, in national parks. But even then, they face the challenges of being recognized as legitimate users of these resources. And I'm sure the same challenge would come across in the ocean.
This is a really important topic. Which country actually do have a recognition of the indigenous communities, particularly for the coastal? We don't really have that many. I think there's just only like 3 or 4, and one of them is Germany. About like 5, 6 years ago, I created this database of global indigenous seafood consumption. I basically just looked at any coastal indigenous community eating fish, and then that was a database. We had about like 600 points. The motivation of creating this is whenever I go to the ocean governance platform, and then talk about the importance of the seafood as food sovereignty, people tend to say, well, a lot of consumption or the eating preference has been changed. Those people don't really eat fish anymore, or they can't catch fish anymore. So I really wanted to create something to show them, no, it's very important. This is what we need to protect. And that is really, this is a fundamental challenge to actually speak to the people. And when it comes down to the MPA or protected area, great concept. It's very important. But unfortunately, the shift that I see for the last maybe like 15 to 20 years, the MPA became more about like the bigger is better. And because historically, oppression to the marginalized communities really comes with taking ownership out creating spatial management, but that's really not the decision that should be made people outside.
Thank you, Yoshi. I think you bring up a great point that drives home the importance of strengthening public participation during the decision-making process for MPAs and other ocean policies. And before we conclude, I want to move on to our third application, which was this idea of protecting people for the planet. And this is specifically in conversation with the idea of the rights of nature, which has emerged both as a theory, but also a legal practice now and has been recognized in several states and in several legal systems. As the rights of nature movement has gained traction globally, maybe we can start by discussing just how it intersects with the idea of ocean equity.
Yes, there's a really direct connection here. And what I am encouraged by in seeing the rights of nature movement develop is that it does look to shift the paradigm about how we regulate the environment by giving nature itself rights rather than having this anthropocentric lens of humans determining how much we're going to pollute the environment. What's encouraging from an ocean equity perspective with how rights of nature is evolving is this notion that it is connected to human relationships with the environment. What we've seen in some recent advisory opinions, particularly the Inter-American Court of Human Rights Climate Advisory Opinion from 2025, is this recognition of these two spheres of legal governance, the idea of rights of nature and this human right to a healthy environment really are fundamentally interconnected. And so we had this previous tradition of one or the other, that these were fundamentally incompatible goals. Either we're going to protect the environment itself or we're going to protect humans' interest to use the environment, but we can't achieve both goals simultaneously. And this international human rights approach to humans' rights to a clean and healthy environment is proving to be the right fit for those seeking to advance ocean equity, because that is the idea, that we can and should have these win-win situations, that we are being ambitious about protecting the integrity of the marine environment, and we're simultaneously seeking to uphold the integrity and the traditions and the access of Indigenous and coastal communities to the marine environment and its resources.
Yeah, that's a really important point. And I think you're absolutely right that some of the best legal outcomes that have emerged out of this really do emphasize that connection between the rights of nature and the human right to a healthy environment, particularly, as you mentioned, in that Inter-American Court opinion. And it's really encouraging to see. But I'm also curious to ask what risks arise when ecosystems are protected without centering the people who depend on them. And with the idea in mind that you all are cautious to warn that there is also the potential for this kind of rights of nature movement and concept to get co-opted into the idea of total conservation, right?
Yeah, Sebastian, exactly that. That was the concern that I had when people started talking about rights of nature. It was an immediate red flag for me. Then I spoke to Randy, and when we look at where the rights of nature really come from, then the origin is really rights for the nature being pushed by the community. And they really consider the no boundary between nature and culture. And ocean equity itself is considering ocean as an extension of the society. What I'm hoping is the idea of rights of nature as something coming from the community and something attached to this idea of the human rights. I think that's really the fundamental.
This has been a really insightful conversation so far. And as we kind of wrap up, I'm curious to ask, where do you see the most promising opportunities for near-term change or long-term change as well?
Well, certainly this is a process, not a flip of a switch to incorporate ocean equity more fully into ocean governance. But we certainly face some significant challenges that are unfolding before our eyes this year and for the past several years with respect to two contexts. One is deep sea mining governance, and the other is marine geoengineering. Both of these practices are potentially devastating threats, not just to the marine environment, but certainly to Indigenous and coastal communities we've been discussing, and how there can be significant negative ramifications from both of these practices on their way of life. Both of these spaces are brand new in terms of the governance of them. And there's a lot of concern about getting it right in terms of how we proceed with governing these new and potentially dangerous endeavors in the marine environment. And so that's really an opportunity to introduce ocean equity as part of that conversation and making sure that the communities that are potentially impacted by these, that they will absolutely have a seat at the table and their concerns will be given elevated relevance because the stakes are so high in these two engagements with the marine environment. So I see that as a source of hope, certainly no guarantee of a just outcome, but ocean equity has an opportunity to itself and be part of those very important ongoing conversations in those two spaces.
Absolutely. And I'm glad you brought up deep sea mining because it's something that ELI is working on as well. And I think it really highlights some of the concepts that we've discussed today about systemic exclusion from decision-making processes, for example, when it comes to the U.S. territories and their ability to engage in these consultation processes around these exploration and exploitation permits in the Pacific. So definitely a lot of discussion to be had in that area as that progresses on. And Yoshi, if you had one core idea that you'd hope listeners would take away about ocean equity, what would it be?
About 5-6 years ago, we needed to make effort to speak about equity in the ocean context. But now I don't have to convince people how important equity is for the oceans. It's quite clear. And for me, that's the hope. So my work is pretty much make the cases, make the tools, do education, and make sure that we just keep on progressing, not to back down.
Great. Well, thank you both so much for joining me today. It has been an absolute pleasure to discuss this with you and to learn a little bit more about ocean equity and Ocean Nexus's work in the subject.
Thank you very much. It's been great. Thanks a lot.
Thank you, Sebastian. This has been a great opportunity to discuss this important issue and really have enjoyed the conversation.
Today, we covered a lot of ground: the distinction between equity and equality in ocean policy, the limitations of traditional frameworks, how anti-subordination theory offers a path toward meaningful remedies, why free, prior, and informed consent must go beyond procedural consultation, and how ocean governance policies can either reinforce exclusion or help build more just and durable stewardship models. We also looked ahead to emerging challenges, including deep sea mining and marine geoengineering, and why these moments represent critical opportunities to center coastal and indigenous communities before legal and institutional pathways become entrenched. If this conversation resonated with you, we encourage you to share the episode with colleagues working in the space. And as always, you can find more resources on our website. Thanks for listening to People, Places, Planet. Until next time.
Thanks for listening to People, Places, Planet, the official podcast of the Environmental Law Institute. Our work wouldn't be possible without the support of people like you. If you'd like to learn more about what we do, attend one of our events, or support our work financially, head to eli.org.